Here's something that will make every litigator's heart stop. Your adversary has taken an appeal from an order that you won in the lower courts, and you find out that 6 months ago, your adversary perfected their appeal by filing an appellant's record and brief. Now, if you know anything about appeals, you know that is a serious default. My name is Zara. I'm an appellate attorney. I handle appeals in state, federal, and immigration cases. I'm based out of New York, but I help attorneys all over the country with their appeals. I also help attorneys in New York navigate the appellate process here in New York. So that's actually a true story, that lawyer who called me in a panic one day with his heart stopping because he did not ever get notice of the appeal that the record and brief that his adversary filed. How did this happen? First of all, this happened in an e-filed case, and you might think that this won't ever happen to you, but the e-filing cases are increasing all over the country. They've been far more advanced in other states than in New York, and now in New York, since the pandemic, they've been converting all the cases over to e-file. So this is a scenario that you really want to avoid. Now, the first thing that happens in an e-filed case when you're filing an appeal is that the appellant will file the notice of appeal in the Supreme Court, in the county where the order was rendered. All right, we're all familiar with that. We all know what happens. Now, in an e-filed case, you, as the attorney registered for that e-file case, you're going to get notice that they filed the notice of appeal. Now, here's the catch. The appellant also has to file the notice of appeal in the appellate division. There is a separate docket for appeals pending in the appellate division than in the lower court. They're both under the same e-filed system, but they're in separate parts. Once the appellant does this, now the appellant has 14 days to file the notice of appeal that was first filed in the Supreme Court with the appellate division, all of this e-filed. They're going to send you, the respondent, a notice. And the notice is very important. You cannot ignore it. So if you know that your adversary has taken an appeal, you need to be on the lookout. It's a hard copy notice, and it's a notice of the docket number for the appeal. And it also informs you that you need to go onto the e-filing system and register as the attorney for the respondent in this e-filed case. Now, here's where a lot of attorneys get into trouble, because this particular case where the attorney missed a brief that was filed 6 months ago, I've heard less severe cases from a lot of other attorneys. So the problem is that if you are registered as the attorney in the lower court for the e-filing case, you have to re-register. You have to go onto the e-filing system, the NYSCEF, input your information and state that you are the attorney for the respondent. Only when you do that will you get e-filed notices. Now, very important, because there's a statute in the rules. All of this comes from the new rule changes that were enacted in 2018 in New York. And one of the rules is that if you, as the respondent's attorney, do not go on to the e-file system and register as the respondent's attorney, then you will not receive the e-filed notice of the appellant's brief or his record. Therefore, you will have no idea that your time to respond has been triggered and has expired. So try to avoid this situation by looking out for the notice when you know that your adversary is taking an appeal, and going on to NYSCEF, inputting your information, even if you've already done it in the lower court, inputting it again for the appellate court so that they know that you are the respondent's attorney and that you are the one that will get the e-notices of the appellant's brief and record. Now, incidentally, what happened to this attorney? Well, I helped him file a motion to vacate his default. It was, we had to be very careful and apologize a bit for not being familiar with the new rules, and to ask for the court's lenience and permit him to file the brief. That motion worked. I think it will not work for very much longer, because they expect the attorneys to be familiarizing themselves with these new rules. And at some point, they're not going to accept the excuses anymore. So do yourself a favor. Know that you need to look out for this hard copy notice that's going to tell you when you need to register your e-filed status for the respondent, and make sure that you don't get, that you don't have to call me in a moment of panic down the line. Thanks so much for watching, and I'll share more tips with you again later.